Hi, everyone. Hi. Welcome back to the asylum. I once again forgot to adjust the. Oh gosh, I'm a guy. Sorry, I had YouTube open on another tab. Anyway, sorry. Let's get started. I'm a mess today. I'm a mess. At any rate, let's start all over again. Welcome back to the asylum, everyone. I'm Dr. Funny Girl. And once again, if you watched my last live stream, I totally forgot to adjust the time on my laptop. So I am here a few minutes early again, but that's okay because I've got quite a bit that I'm hoping to get through tonight. And in about, hopefully, I'll probably be, I don't know, just over an hour online tonight. Yeah, watching a couple of some crazy Karens in court. So if you're in the chat, pop in, say hello, and We're gonna get started here in a minute. While I give everybody a minute here just to come online because I am early. I am actually going to do a quick Google search. I haven't had a chance yet today. I wanted to see if there was an update on the Lily and Jack Sullivan, uh, to see if there's been another update. I haven't heard anything, but I also haven't checked the news yet really today. So just taking a quick look here. Doesn't look like there's any new updates from the RCMP regarding the search. So hopefully, again, just please keep them in your thoughts, keep them in your prayers that those two children are found and are brought home. Um, no family deserves to go through that, what they're going through right now. So, okay, so tonight we are going to do something that I haven't done before. So, you guys are all going to be my guinea pigs as my reactor audience. I am going to react to some YouTube videos of some people having some crazy meltdowns in during court while they're in court. All right, so I do have a few of them picked out. I don't think we'll get to them all, mostly because in order sometimes in order to kind of understand the complete meltdown, you have to watch the entire proceeding, and court can be quite tedious, even though there is bouts of excitement. And so the videos are, on an average about 10-11 minutes long. So we're going to get started on that. I will post the YouTubers channels that I'm getting the videos from. So if you guys can, please go and sub up to the YouTubers whose videos I'm using. Hopefully none of them will copy strike me. We'll see. Like I said, this is the first time for me giving this a whirl, but we're going to give it a try. All right. So let's get started. Also, I'm just going to let you all know that uh, we've got some pretty crazy wind happening right now in my area, and I think we're expecting a thunderstorm. And my power almost always goes out when we have a thunderstorm. So if everything just cuts off suddenly, that will be the reason why. All right. Okay, let me get the first video up here. All right, the first one, let me click the link. It's from Judge Middleton. Oh, oh, it's from Judge Middleton's court in Michigan. I actually watch him pretty much every day when he live streams. I quite like his videos. or his live streams. I am not having a good time with my words. People, I can't. My brain is not functioning. I quite enjoy watching him in court. He's very calm. He's very experienced, and while most of the cases in his courtroom, again, nothing very exciting. I don't know. He just I just enjoy watching his live court proceedings. Okay, I gotta figure out here what I just tried to click the link. I saved the link on a different page, um, and it didn't open. Okay. All right. So sorry. I'm not sure what I've got going on here. Because again, first time, bear with me. Okay, let me see if I can get it from my downloads. I believe this is it here. All right, let me go to the timestamp. So this one I labeled Mr. Roberts, who is the defendant in this case. Yes, okay. All right, let me share my screen. Hopefully you guys can hear it. Oh, the boys are barking. Just 1 second. All right, sorry about that. They heard something outside, so they started going crazy. Okay. All right. All right, here we go. We're going to get started here. All right, so we're about to get into the case here. Oh, I need to share the video.
I had to
Sorry.
get my stuff downloaded and had kids helping, and nothing is working. So thank God for the phone number because I don't have a ride.
All right, there we go. I think I got it. Okay, so this is a civil case. This gentleman is being sued by an insurance company, and you're about to hear the reasons why and where they are in this stage of the case. All right, and he's not a happy camper. Okay, let me hit play again.
All right, well, this is a court appearance and it affects a lot of money, and people really should take things more seriously than they do. But let's talk about this case. Attorney Tiffany Palmer is here on behalf of the plaintiff.
Good morning, good afternoon, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
I hope the volume's okay. And also, just to let you know, the defendant in this case actually calls in on telephone, so you don't actually see him. It's just a phone call.
And Mr. Bradley Roberts is here by telephone only.
Yes, sir.
All right, this is a claim by Liberty Mutual Personal Insurance Company versus Bradley Roberts. And this has had a bumpy ride. We've had a couple of previous hearings on this. We had a hearing on March. Let me go back even all the way to the beginning.
So Judge
hearing on
Middleton's just going to explain the
16th.
case now.
Mr. Roberts appeared. He admitted there was no insurance on the vehicle at the time, and it was screwy facts. The vehicle was allegedly owned by Cindy Vandegrift. It was insured as Jessica Adams, and a driven vehicle was driven by her son or nephew, Xavier Adams. Anyway, there was an accident, and no police report was filed, and so all these facts were raised, and so they just continued the matter for 90 days for additional discovery. Mr. Roberts didn't show up. We continued the matter to March 31st, 2025. And Mr. Thomas Duquette was here. So we adjourned the matter for 90 days for discovery, and the defendant never complied with any of the discovery.
So Mr. Roberts, the gentleman on the phone, never showed up for a hearing and never complied with the discovery request.
So he didn't answer any of the plaintiff's requests for discovery, and he didn't show up for the court hearing. So Mr. Duquette moved for a default judgment, $10,415 in costs, in damages, $232.13 in costs, and a $75 attorney fee. So judgment entered by default on March 31st.
Which should have never happened. You heard me say she jumped in it and started it and put it in reverse. She took control of the vehicle. It was hers, not mine. She's using mine to go to work right now, or I'd have a ride there.
Okay. Well, you didn't show up for the hearing. That's not her fault.
And I paid someone that day. And they didn't make it to come and get me, and I walked home from work to make sure I got on the Zoom. I'm sorry, but this is making me mad. I shouldn't even be here.
So he's already quite upset about what's going on. He couldn't make the hearing. He had to walk. So he's already upset.
That's open for discussion. You think you shouldn't be here. They have a different idea about
exactly.
Well,
when someone jumps in a vehicle, they assume responsibility.
Do you have a legal citation for that? Or is it?
I bet he does not have a legal citation for it, Judge Middleton.
Just something you read on the back of a cereal box. You're under the no fault statute, and it's complicated, and you're in over your head. So you don't show up for your hearing. You don't answer any of their requests for discovery. They sent you information. Everything you've told me, none of it's under oath. This happened, it belonged to somebody. Somebody told me they backed into the car. None of it's under oath. It's just what you claim to be true. So they send you a number of documents for discovery, and you don't answer.
I don't know what that means.
Well,
I don't know how to do all that. I'm not a good lawyer. I don't have any help. I couldn't hire an attorney because no one would take the case.
Yes, it's a tough situation.
I'm tired of getting ragged on when I'm trying.
So he's obviously had a lot of issues with this case, and something that Judge Middleton points out in a minute, he says that this is not a small claims case. It's a civil, general civil matter case where the rules are a lot different than small claims. So you really do need a lawyer in these type of cases, and this gentleman didn't have a lawyer.
All right. Well, all right. You may be trying as hard as you could. Maybe you could spend $50,000 for a lawyer, and the no fault statute still applies. So anyway, you don't respond to the discovery. Everything you're telling me, this isn't how the legal system works. You show up and say, hey, judge, this is all a big mistake. Sorry. Here's what really happened. Please dismiss it so I can go home.
They're doing.
Well, they filed legal pleadings.
That should have never happened.
They're here to provide.
The plaintiff shouldn't file legal pleadings? I'm not sure about that.
Testimony regarding the matter. In fact, we took some testimony, or at least some legal representation, on March 31st. So anyway, you don't show up on March 31st. The judgment enters a few days later. and you file a motion to set aside the default on
I did
April
call that day.
14th, which it was in 21 days of the default setting aside. So when you move to set a default aside, there's a certain standard you have to meet. You're supposed to file something called an affidavit of meritorious defense, and you're supposed to show good cause for why you did not appear for the hearing. So in your motion, which you filed on April 14th, I'll just read it. On March 31st, a person who lives with me borrowed my vehicle to look for a job. I totally forgot. Although I called the court around 8:05 and left a voice message, I was going to be late because of no ride. So I walked a couple miles, got a ride. Then when I was home and on Zoom, for some reason, my tablet would not work, the microphone, no matter what I did. I have a meritorious defense for this claim. I, Bradley Roberts, and Keith Ryan, seen Cindy Vandergriff, also who own a 2005 GMC Envoy. Cindy got in the vehicle and started it and then reversed it, which in turn slammed into the plaintiff's parked vehicle, knowing the vehicle had no insurance. Therefore, knowingly take possession of said vehicle, the plaintiff then left the scene. No police were called. And somewhere, someone later gave the plaintiff an old insurance card, which had my information on it.
So he just explained why he doesn't believe he's liable for the insurance claim on this accident. That's his meritorious defense to the claim, not to the judgment.
Correct.
Which is different than what you told me at the hearing back in December of 24. So,
oh, and his story has changed apparently.
I'm not sure that establishes an affidavit of meritorious defense or a legitimate reason for not coming. I don't have any notes in the file that you called. I don't say that you didn't. The hearing was at 8:30. At any rate, I called the hall and checked around and you weren't here. So having laid the premises out, Ms. Palmer, what's your position here?
Our position is that the defendant has not met the statutory burden in order to set the judgment aside. As the court has indicated, the information he provided as to his failure to appear for a court-ordered hearing, it doesn't rise to the level of good cause, but obviously the court is the gatekeeper of that. But our position is that it does not rise to that level. And then the meritorious defense that was advanced, it is not necessarily consistent with what was originally indicated. And this could have been helped if the defendant had answered the discovery. So right now we're not exactly sure what the defense is. And although I know the courts are somewhat liberal as it relates to advancing a meritorious defense, this is an affidavit. So I couldn't even necessarily use this statement if the court was inclined to set aside the default judgment to impeach him or to have him basically attest to these facts. So he could theoretically change his version after this point too. So we believe that he has not met the statutory requirement to set aside the default judgment at the bare minimum.
Let me see if I understand. Mr. Roberts, are you contending that this is a completely different vehicle?
No.
All right, so I think the judge here is still trying to figure out exactly what happened in this accident because the defendant is just not speaking clearly the facts of the case or what happened. So,
well, it's the same vehicle. I gave them her phone number. All they got to do is call her and talk to her. I thought my stuff would be taken care of and thrown out because I shouldn't be here. She said, here's my information, and she lives with me still. You know, it's simple. Contact her and not me. I didn't do it. And they haven't contacted her at all.
All right, but one thing that you, from the beginning, failed to accept
Okay.
is that you're the
Confusing.
insurance holder on the vehicle.
Yep, I was. That's
Okay, so he's saying that he does hold the insurance on the vehicle, but oh, hi, Queen Cat. I'm just having a night. Hi, Queen Cat Lady. Hi. Thanks for joining. Appreciate saying hello. Uh, we're just working this. We're watching Judge Middleton here. We got our first Karen up. His name's Robert or Mr. Roberts.
what started all this, because someone got my information.
Yes.
So, and I'm not sure if this is the right.
So here now, the plaintiff, the lawyer for the plaintiff, is trying to figure out what the hell's happened here too. She's
way
confused
to
as
do this,
well.
but I was confused in what his defense was here. I thought he was saying it was a vehicle that looked exactly the same as his vehicle that
No.
was completely separate. So he's saying that someone got into his vehicle and then drove the vehicle. Is that what this defense is here?
Yes, she got into her 2005 Envoy and yes, drove the vehicle.
The lawyer is totally confused. She's like, "What is going on here?"
That you were the insurance holder on.
Well, used to be at that moment though, and she knew there was no insurance on it because it had lapsed. I wasn't driving it. It was parked.
It's crazy.
Your Honor, based on the defendant's statement, and I understand he's not under oath. So I misstated maybe in how I responded to the meritorious defense. But if he was the title owner, registrant, or constructive owner of the vehicle,
Never.
he's still legally responsible for whoever's driving the vehicle if they had permissive use.
Yes, he doesn't
Right.
understand. But his argument
But
is,
then when she jumped in it, yeah.
she drove it all the time. You guys were playing fast and loose with the rules. The car was titled in somebody's name, insured in somebody's name, driven.
Oh, I agree, Queen Cat Lady. Yeah, so yeah, it's just it is. There's so many people out there. Yeah, we're gonna cover a few of them tonight. Yeah.
by somebody else. There's an accident and the insurance is in your name and now you're outraged. It's your own fault. Then none of this is under oath. I don't know who this car is registered to. I don't know that she's the registered owner. I don't know all this other stuff you told me on December 16th. What you told me in the other letter is different.
Somebody's getting confused because it's simple. Cindy Vandergrift.
Yeah, I think we're all a little bit confused about what's going on here. So I guess he's gonna try to attempt to explain it again. So let me just tap it back there a second.
The vehicle if they had permissive use.
You can
Yes,
hear
he
his
doesn't
explanation.
understand.
So,
But his argument
But then
is,
when she jumped in it, yeah.
she drove it all the time. You guys were playing fast and loose with the rules. The car was titled in somebody's name, insured in somebody's name, driven by somebody else. There's an accident and the insurance is in your name and now you're outraged. It's your own fault. Then none of this is under oath. I don't know who this car is registered to. I don't know that she's the registered owner. I don't know all this other stuff you told me on December 16th. What you told me in the other letter is different.
Somebody's getting confused because it's simple. Cindy Vandergrift is the owner. I borrowed it because she wasn't driving it. So I insured it. Then I quit driving it and it was parked. Cindy Vandergrift's still the owner. And then Cindy Vandergrift that
so
day,
all we know about that is what you're saying here, and you're not under oath. You never filed.
Right. And I'm saying call her and she'll tell you all.
Could you imagine? Don't you wish court was just that easy? Just be like, I didn't do it. Just call this person. They're the one who did it. Why are you bugging me? Like,
That isn't how it works. They
Well, it
sued
should have
you.
been, because I shouldn't be here getting upset. And you shouldn't have to deal with me.
Well,
well, I agree with that, and I think Judge Middleton does.
I wish it were true.
Yeah.
Yeah, I know. Okay.
All
I'm
right.
sorry.
So they send you a bunch of documents to ask you these questions. Who's the car registered to? Show me the title. Who was your insurance carrier? When was it insured? You didn't
How would
answer
I
any
have
of
the title if I don't own it? So I have
You ask the owner of the car for a copy of the title and include it in with the discovery.
no idea to fill this stuff out. No idea
Yeah.
how to do it.
So all you have to do is show up and say, hey, I don't own this. I don't have any proof that I don't own it, but they're showing that you're the insurance
I did that the first. Wouldn't that be the first meeting we had when I left them her phone number and contact info? It would have been taken care of. If they would have followed through and said, okay, you're not the owner, I'm going to call this number, they would have found out who the owner was legally.
But I think that's what they're trying to tell you, though, is that's not the way it works. I think it's the fact that you had the insurance on the vehicle is why you're liable. You're being held liable.
All right.
I
Anything
can get
further?
on Michigan website and do that.
Here I'm in just in response to this last argument. Obviously, it's not appropriate to somehow switch the burden to the plaintiff by saying that we were supposed to call and then I guess somehow add her to the lawsuit. We don't have anything definitive to even be able to sue Cindy upon. Maybe if he answered discovery, maybe if he had sworn statements, any of those things. But he just has his versions that he is,
I see what
advancing
you're
that
saying,
we cannot rely
but I
upon.
didn't understand.
That we cannot rely upon. So that's why it was critical, and that's why the court opened discovery and allowed us to have discovery for him to answer discovery. That's why it was important. And if he didn't know the answer to a question, could say he didn't know. It's plenty of questions on here. I think 12 interrogatories, 5 requests for admissions, and a request for productions, I believe. So it's quite a few questions on here.
Oh wow, that's a
First one
lot.
being his name.
And I didn't understand how to.
He didn't understand that he had to put his name on the form. Judge Middleton often
Mr. Roberts,
takes
you
a minute
point
to
out
answer.
a good and valid point. People get involved in a general civil lawsuit. They don't understand the rules. It's complicated. You're not in small claims court, you're in general civil court. And every day this week, including tomorrow, I have multiple people who are driving around with no insurance. And last week on Thursday, I had 7. Probably had 10 last week. I probably have 10 this week. And you point out what happens when you're driving around without insurance. You get into the weeds when you get sued by the other party's insurance company for an accident. And you're in the weeds, all right. You barely filed an answer. You didn't show up for the hearing. You didn't answer any of the interrogatories. And you haven't shown an affidavit of meritorious defense. And I'm not sure we have good cause for why you weren't here. So your motion to set aside the default is denied. Good cause and meritorious defense were not established. Now, you can sue her if you think she's more liable. She doesn't have any money either, and I doubt they're going to get any money out of you. But
when she jumped in it and started it, isn't that taking the known possession of the vehicle back?
No, it's
So
not.
therefore, it
It's
would be
not.
under her term. Okay.
No, it's not. All right, I'm
Oh,
gonna send you an
when
order
it's her
denying your
vehicle.
motion. And if you want to appeal that further, I guess you're welcome to do that. But for the reason
Wow.
state,
Thanks.
you are liable for the amount here. You can't even get to court. You have
This
to
is
call by
what-
telephone. And
Yeah, this is
so,
why our country works great. Because Cindy's using my car. I said that.
sorry about Cindy using his car, but that isn't gonna go very well forward. But for all the reasons I stated,
All right, so that was our first Karen. That was kind of a warm up into what we've got coming. So I know the clips are a little bit longer. It's kind of just the way it works with court cases. There's not, sometimes you got to understand what's going on to see the freak out. But so we're gonna move on to our next one. So the next one is actually a sovereign citizen in Judge Simpson's court. And this one I think is actually quite humorous. So let me pull it up. All right. Present. Let me see. I'm wondering if. Oh, that doesn't work. Okay. I just wanted to see if there's a different option for me. But all right. Okay. So Judge Simpson again, he's another judge out of Michigan. So this one's good. It moves along pretty quickly, actually. All right, here we go. All right. Oh, it's not sharing, is it? Sorry. Oh my gosh, guys, I'm so sorry. I swear I know how to do this. Barely. Barely, barely, barely. Okay. All right. Okay, why isn't it showing up? Oh, here we go.
I understand your charge.
All right, there we go.
Understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Tell you what. Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time, and I'm not
I will just say Judge Simpson doesn't really take any crap in his courtroom.
going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it.
All right, here we go.
State your name.
Round two.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of
Not, okay, not my question. You understand that there can be serious peril in representing yourself.
So the thing with the sovereign citizens is they don't believe in the justice system, right? They believe that state statutes and things like that aren't valid laws, and that they don't have to obey them, and the Constitution overrules all of those things, even though I believe the Constitution says that states have the ability to write their own laws and act their own laws. So, yeah. So they do everything they can to avoid following normal court procedure.
I recognize what you're saying. I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there. You
Judge Simpson's like, all right,
recognize.
that's it, enough.
Do you understand that that in any of the proceedings, that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
Overstand. What does that mean? I overstand what you're saying. Oh, these people.
You want to be,
Your Honor,
you have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat.
Strike two.
You can play games with me all day. I got all day. I got all day. Have a seat.
All right.
The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Afternoon, Your Honor. Daniel Magoo.
Okay, here we go. Round three. Let's see if we can get it.
You're in sui juris.
All right. So on this matter, I was apprised of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Right, Queen Cat Lady, that's the thing, right? They think that they're smarter than everyone else, right? They think that they can outsmart everybody, but they do. They just look like complete morons. Like, oh.
Listen, sorry.
Oh, so then he leaves the podium.
I apologize, Your Honor. I meant no disrespect.
Funny, he means no disrespect, but he won't answer the questions the judge is directly asking him.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
So that's another common response that sovereign citizens have in court. They often say they do not understand what's being asked, or they do not understand the charges, or they do not understand the jurisdiction that the court has. It's delay tactics that they have. Hi, Vibe. Hi. Thanks for stopping in. We're watching some crazy on in court today.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my.
Did you see the Did you see the lawyer here in the white hair behind him? When he started to say that, he was just like, "Oh my God, what is this guy doing?"
Rights, and the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting
the
for
charges.
what to occur?
Well, under the rights to due process, Your Honor, Fourth, Fifth, Eighth Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a
Judge Simpson is like so done with this guy. So done.
police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just
You know, it's funny he makes that comment that
asked
because
you
of the
before whether or not you
sorry,
understood.
because of the charges that are pending, I guess, against him. He lost custody of his son, and he wants to make sure justice is served. But like he's not following the procedure, so it just blows my mind that I'm not saying that in some cases, you know, decisions in courts and stuff shouldn't be challenged because obviously they should. But like this is literally, I think this is just an arraignment or like it's a very early hearing. The judge is just trying to get on to it so he can move on to the next case in his docket.
The charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why
The judge is like, no, don't.
you don't understand.
I'm trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you
You're asking
believe
me.
that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will, do not interrupt me.
I can object to
Do
that date.
not interrupt, do not. One more time, you're going. I've given you fair warning.
And this is what I don't understand too about, and again, hi, Lady Starfire. Hi. Welcome. Thanks for stopping in and saying hi. Sorry. Is because everybody here is an attorney by default for much court TV. Yeah. I mean, I watch a lot of court on YouTube, so I get that. But, the sovereign citizens is a whole other, in fact, I'm hoping one day to do a stream on it because it's a whole other ball game. Those people. Yeah, they're out there, some of them. So.
I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may
violation.
leave now.
Let's go.
The bailiff.
I have a right to
You
a
may
counsel.
Let's go.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself.
I think that attorney that just stood up behind him is ready to flee. He's like, I don't give him to me, judge. I'll give him to someone else.
The only one that was there in this courtroom. No one was there I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations
do
that need
you
to
wish to be represented by an attorney?
take an oath to defend the Constitution of the United States of
Then,
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my court.
Right, they make it so much harder on themselves. Like it's just simple questions. So, oh, he's a sovereign citizen vibe. Yeah, they don't believe they need to follow the laws of the land or state statutes or yeah, they're a whole different breed, sovereign citizens. All right. So, what are we looking at here time-wise? Like I said, 'cause I know these take a bit. Okay, so I'm gonna move on to the biggest Karen. Like I said, I did have a few videos, but they are quite long. So we'll move in. Actually, I will. There is one that I did kind of want to watch a few minutes of just because she's quite funny. We won't watch the whole thing, but she, uh, her face expressions quite humorous. So uh, they end up having audio technical issues, so her expressions during it are funny. Let me see if I can find it here. Um, Here we go. All right. Let me share it, and then we'll share screen. All right. So this one had me laughing. All right. Turn the unmute it. Oh, and sorry guys. Sorry, let me pause it again. Is the sound are the sounds for the videos coming through okay? Is it loud enough? Because like I said, I don't normally I don't share videos a lot, so I just want to make sure they're okay. So let me know. So yeah, like talking about the the pathology of sovereign citizens, yeah, it's I think a lot of it is their doctrine too. Uh very it's cultish as well. Yeah. So Lady Starfire's making up salads. Nice. Nice. I had a big salad for my lunch and then I came home and had tater tots for dinner. I swear I eat like a toddler. I wasn't that hungry, so I just had a few tater tots for dinner. All right. Okay. Let me get. All right. So this is out. This is Judge Webster. Oh, am I sharing? God, guys, sorry. We'll get this figured out, I swear. Probably not, but I'll keep saying I'm going to do it. All right. Judge Webster. And I just wanted to watch a few minutes of this one just because her audio, the audio is quite bad the first couple of minutes, but the expressions on the defendant's face are just, yeah, you'll see.
Please move the county jail
So,
camera so we can see all of Ms. Reeves. There we go. Okay. We are on the record in 2022, CR 180, State of Kansas versus Levita.
so this is the county attorney, I guess, up here, Judge Webster. Judge Webster's got something funky going on with her hair too. She's got quite the look going on as well in this video. I'm not sure, like helmet head reminds me of uh Spaceballs.
The state appears by and through Ms. Jill Gillette, Greenwood County Attorney. Ms. Reeves appears in person, in custody, and per se. Is this just a motion to revoke probation, Ms. Gillette?
Yes, Your Honor.
Look at her face. Like making faces at the camera.
She doesn't have an attorney, Judge, because they just did a warrant and then she was arrested.
And just when I don't know, it just made me laugh.
She
Just
was
the
last
faces
here
she was
December
making in the
13th,
camera,
2022 at the
her
Children's
reaction.
Courtroom. And there was been 3 negotiations, and she pled guilty to count 2, which was violation of a protection order, and she was sentenced. So we're all, okay, motion to revoke probation. I see.
She's like, finally, Judge Webster, you got
So
to
Ms.
it.
Reeves, the state is wanting to revoke your probation on the grounds that you failed to pay your costs and fines. as
Oh, I'm sorry.
directed,
Judge Webster's
adding a
here. This
balance
is
I'm
of
just
sorry.
killing
I
me.
can't hear you at all. You're let's completely unclear. I totally can't hear you. Seriously. I'm being for real.
I understand. I've been being
I
told,
cannot hear you, Judge Webster, honestly.
Deputy, is there anything you can do?
You are very quiet in the jail, Judge.
And there's nothing you can do to turn that up?
The computer is on max. It was this way with the last 2 hearings.
Like completely maxed out.
Listen, you want to look at this again?
I don't know what to say. Judge Webster, honestly. We can't hear you. We honestly can't hear you anymore.
All right. So I'll end that one there, but that one just kind of made me laugh. Just her faces in the camera, and then telling the judge she couldn't hear. So, all right, now we're gonna move on to the Queen of Meltdown. So this one again, it's a bit of a longer video, just by the nature of it. So, but it's quite something. The meltdown from the defendant is crazy. So also, before I forget, most of these videos I'm watching are from a channel called Old Squishy Gardener. I will put the link to their channel in my description after the video, so please go and sub up to them. They put out some great content for court. All right, so here we go. Let's watch this last one. Okay. And then, okay, here we go. So again, the beginning is like details of the case, but it does the Karening does start off pretty early.
Good morning, I'm Cheryl Luckoff on behalf of the plaintiff.
All right, thank you. And Ms. Stevenson, if you can please unmute. All right, thank you. And Ms. Stevenson, your name for the record, please.
Hi, Jacinta. Hi, thanks for stopping in and saying hi. You got here just in time. We're watching the Super Karen of the night.
Scheduled.
So.
Okay, so there was a bankruptcy stay that was entered November of 2022. And then there was an order reopening the case after bankruptcy. And so this is the hearing for that. And so counsel, you had an opportunity to speak to Ms. Stevenson in the breakout room, correct?
Yes, Your Honor, and I'd like to create a record right now. So the defendant had her initial hearing on November 4th, and she filed a bankruptcy right before that hearing. She did appear, she was given her rights.
So this is an eviction hearing this is the defendant. Last name is Stevenson. And apparently she's claiming she filed a bankruptcy and that's the reason why she can't be evicted. So that's kind of the basis of this hearing. So they're just providing a little bit of background information here now.
Her bankruptcy, she had filed a Chapter 13. It was dismissed for failure to comply. She paid $0 into her plan. She had not paid.
Okay, so she filed for bankruptcy and then never complied with it. Kind of sounds like someone else we might know.
She had not paid the landlord rent since September of 2021. Since that time, she had Sarah payments. She has a balance right now of $12,100 $106, Your Honor. She informed me in the breakout room she's filed another bankruptcy. I don't have any notice of this bankruptcy. There's no bankruptcy attorney here, but that is what she is asserting. We are going to be objecting to any discharge because if she filed it right before this hearing again. And there clearly seems to be some abuse here, but she can provide the case number for the court. And, if a stay needs to be in place, then a stay needs to be in place. But I have no knowledge personally of any bankruptcy, and my client has not received a notice of bankruptcy proceeding.
I forgot to say too, Judge DeSanto, she's also out of Michigan. I think she works in the Wayne County. She sits on the bench in the Wayne County area. So for some reason, we get a lot of this stuff out of Michigan.
Okay, Ms. Stevenson, please raise your right hand.
Yes, Your Honor.
All right, bye. See you soon.
I've been filed bankruptcy.
Ms. Stevenson, please raise your right hand. Is your right hand raised? I can't see.
Yes, ma'am.
Okay, do you solemnly swear or affirm the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. Okay, and so, Ms. Stevenson, I'm not sure about your connection. It seems to be a little bit spotty, but
yeah, I was just gonna say, to make this situation even worse, the connection is bad. So it just makes the whole thing just even worse. Oh, the trials and tribulations of Zoom court.
okay, so initially you filed bankruptcy in November of 2023, correct?
Yes.
And then that was chapter 13, is that correct?
Yes.
And you were ordered to make payments within that bankruptcy case, correct?
Incorrect.
That's incorrect?
Yes, ma'am.
Okay, so chapter 13, were you required to make any payments at all?
I fired my lawyer for the chapter 13. I reached out to Royal Woods because the payment plan that.
Why do we think she fired her lawyer right before she was supposed to start making payments?
He came up with, I did not agree with. So I fired him. I contacted Royal Woods and I told them about my new attorney. And I just gave Miss Lockoff the case number.
I don't have the case number. Her connection was spotty. She said 23. That's all I have, Your Honor.
Okay.
I can give you the case number, Your Honor.
What is the case number?
Okay, 1 second, please.
So when you file for bankruptcy, I don't know, things are, yeah, I do remember that. Yes, I do remember the cat filter. Yeah, I don't know how it works, but if you fire your lawyer, does that mean the bankruptcy is like null and void, and you have to start all over again? Or the claim here is she's gaining.
My case number is 23-44007.
Okay. When was that case filed?
I contacted them in January, and my lawyer told me to contact him when I received the court papers for eviction or a hearing. So I contacted him, and he filed the case last week. And I did contact Royal Woods as well.
Who did you speak to?
I spoke to Andrew at Royal Woods, and I informed him, and also a lady named Cheryl at the office, at the the corporate office. She emailed me and actually called me. I told her, I said, I have another case, and I don't know why we're going to court. I still need the 30 days, you know, to vacate the premises.
Okay, so just remember she said that she needs 30 days to vacate the premises because she says something completely different in a minute.
She said, okay, we're still going to take you to court. I said, okay, fine. I said, you guys are wasting your time because I'm on another automatic stay.
She's a professional. Your Honor.
So
Respectfully, just.
I'm just a moment, Ms. Luckoff.
Yeah.
So are you planning on relocating then, Ms. Stevenson?
Ma'am?
Yes. Are you planning on relocating then?
Could you repeat that, Your Honor?
Are you planning on relocating?
At my leisure.
At your leisure. That's not how that works, man.
So she just said that because she refiled for bankruptcy, she needs to get another 30 days notice. But then the judge just asked her if she's going to relocate, and she said she's going to do it at her leisure. So, Lady Starfire, funny girl, thank you for the warm welcome. Greatly appreciate it. Hope you're well. Thank you. I am doing well. Thank you. And thank you for coming and staying. So, like I said, I know a bit different format tonight. My first time trying this. If it doesn't go well, then we'll try something else. But I thought I'd give it a whirl. I know the videos are quite long, so I might have to look at doing something a bit different if I'm going to do these types of reactions going forward.
On your own time. That isn't how this works.
Yes, ma'am. See, a bankruptcy.
I'm sorry, your connection is not very good. What did you say after bankruptcy?
I don't even supposed to be here, Your Honor, and I don't even supposed to be here.
Why not?
This is not bankruptcy court. This is not bankruptcy court. I don't even have to explain myself.
Ma'am?
I have right. I don't supposed to be.
So it's like a common theme we've seen throughout these videos, right? All of these people that are so argumentative or just hostile to the judges, they all say, well, I'm not supposed to be here. I'm not supposed to be here. So, it's insane. It's whether you think you should be there or not, it doesn't mean you have to be so rude to the court. So, hi, Gregory Schmeggery. Hi, thanks for stopping by. Karen videos are the best. Yeah, they are. They give me a good laugh some days, So, all right, let's. I'll try not to stop this one too much because it does start to pick up from here now.
Be here, Your Honor. You are not a bankruptcy judge. You are not a bankruptcy judge.
You are absolutely correct. I am a district court judge and I have jurisdiction over this matter because we do not have anything in our files or anything that was filed by you or any attorney representing you that would support your claim that you have filed another bankruptcy case.
I gave you guys the case number on record, so you guys can try me if you want to.
Ma'am, where is the documentation?
See, like who uses, I mean, I know it's crazy. Who says that? You can try me if you want to. I don't know. Just for me personally, and I get it. Like I know our court systems aren't perfect, right? There are a lot of issues in our justice systems. I'm in Canada, and most of my viewers are probably in the US. There are a lot of issues, of course, but I don't know. I've just always, you have the judge is not being rude to her. The other attorneys are not being rude to her, just have just basic human decency. And again, like what gives her the right to think that she is entitled to act like this?
Regarding your case, you should have some paperwork. Please stop interrupting me.
I will email it to Ms. Lockoff right now.
Please stop interrupting me. You can email it to the court at 27dc@wyandottmi.gov.
1 second. Do you want me to do it now? Because I will do it now.
Yes, ma'am. We're going to take a brief recess. We're going to go off the record so you can submit that. Thank you. Okay, Ms. Lockoff.
I'm here.
Okay, I don't know where Ms. Stevenson went. So I'll give her a minute to rejoin. Maybe she had a bad connection, I'm not sure.
Yeah, I guess I see what you're saying, Lady Starfire. The problem, whether you know, maybe you don't, if you don't know what proper courtroom decorum is, I you just treat people with respect, right? Like, I mean, of course, it makes great entertainment when they don't, right? Like, it's funny to watch, but yeah, just I can't imagine going through life being that hateful and spiteful.
Do you, so I'm going to go on the record just so that there isn't any concern regarding ex parte communication. So we're back on the record in the matter of Royal Woods Townhomes versus Marquia Stevenson 222177. The court will note that the court took a recess to retrieve the email that Ms. Stevenson was sending in regarding her claim of a bankruptcy filing. The court will also note that Ms. Stevenson was just on the Zoom and has logged off. I'm not sure if her device logged off or she logged off intentionally. I'm not sure.
But she does come back. She does
What I
come
would
back.
like, Ms. Luckoff, is I'm going to forward this to you as well. But I have a request of you. Do you have access to the bankruptcy court?
I do. Yes.
Okay. So I would like if you could please access Ms. Stevenson's November of 2022 case.
Okay.
And if there's a register of actions of some sort, if it goes through and spells out what that is, if you can email that over to the court, please.
So you want the actual petition that she filed in November?
Yes, it does,
Not
Lady
necessarily
Starfire.
the petition,
But
but so for instance, so like our docket, right? You can see a register of action where the matter was filed, what, everything that went through sequentially, and then whether or not the Chapter 13 agreement.
All right, I'll just bump it forward a bit just to see if I can see if when she comes back, because I think they're discussing the bankruptcy here a little bit. There we go. Okay.
Oh, she is joining. Okay.
What do you want me to do?
I just wanted to be able to see you. That's all. I can see you now. So I did receive your email regarding the communications from Fairmax Law. So I'm going to forward that to, reporting that to Ms. Luckoff. And then Ms. Luckoff is accessing your previous case so that she can send a copy of the register of actions to the court so I can review that. So, because this appears as though there is a skeletal bankruptcy petition and you still have 14 days before your case is actually filed or dismissed. So it doesn't appear as though there's a bankruptcy case at this point.
Right, Gregory? Yeah, I know. I mean, that's a whole new field of like psychology we could maybe open up, right? Like we could just study Karens and their behaviors and see what, where does it stem from? Does it stem from being spoiled, or is it a trauma based response? Is it, just because they grew up as feral animals somewhere? Yeah, that would be a whole new area of research in psychology.
Point that would require this court to issue a stay, to comply with a stay. Nor has there been a stay presented to this court.
I don't know what y'all talking about, but I don't mean to
I'm sorry,
interrupt
you're
you.
breaking up. I can't. You're breaking
Your
up,
Honor,
Ms. Stevenson.
but my case.
Ms. Stevenson,
my case
I didn't hear, Ms. Stevenson, I'm not catching a lot of what you're saying because it's a bad connection. So I'm not catching everything you're saying. So can you please move locations? Okay, so Ms. Luckoff, are you still there?
Oh, yes, I am here.
Oh, okay. So we're going on the record in the matter of Royal Woods Townhomes versus Marquia Stevenson, all occupants, 222177. Okay, and so counsel, your appearance, please.
Again, for the record, Your Honor, Cheryl Luckoff on behalf of the plaintiff.
Okay, thank you. And so Ms. Stevenson is not present anymore. She was on, she logged off, she logged back on. And then I asked her to redo her connection. She said just a moment, and then she logged off. And I think it's been about another 15 minutes and she's not logged back on. So I'm continuing in this matter without Ms. Stevenson. And so, Council, I did receive the,
All right, so I just shared the link there of the channel's videos that I've been watching. So Old Squishy Gardener. So go please sub them up and give them a like on their videos. So
history regarding Miss Stevenson's case number 2248279. So I have a couple questions. And one is, when was the 2022 case was filed October 19th of 22, correct? The landlord tenant matter?
Yeah. Yep.
Okay.
all right, are you guys interested in hearing all the details of the bankruptcy, or do you want me to fast forward it to when the defendant comes back on screen? So let me know. Just put a 1 on the chat if you want me to just let the video play, or 2 if you want me to fast forward it. I'll let it play for now.
And so that's important to note, because then this Chapter 13 petition was filed and entered on October 21st. Now, Ms. Lugoff, prior to filing this action in October of 22,
all right, I'll fast forward.
Ms. Stevenson with the notice to quit?
She received a 7-day demand for possession. Yes, Your Honor.
Okay. All
See
right.
where she comes
So,
back out. There we
my
go.
other question is this. And so the court will have her place her name on the record in just a moment.
All right, so she comes back in a
Ms.
second.
Stevenson,
All right, she's back again. So
can you
this
please
is after
unmute?
I'm
leaving.
sorry about that. I'm here.
Okay,
Yeah.
hopefully you have better, you have better connection right now. Okay, so the court will note the, so I was just going through the procedural history, and based upon your 22 bankruptcy case, your case was dismissed March 6th of 2023. But the final decree and the closing of the case wasn't until April 25th of 2023. And it indicates that the order, the United States Bankruptcy Court, Eastern District of Michigan, Southern Division, Detroit, signed by Judge Maria Axholm, the United States bankruptcy judge, indicates that the matter was scheduled for hearing on March 6th of 2023. And an oral motion to dismiss by the Chapter 13 trustee was not opposed, and was not opposed by the debtors who were present or counsel represented them. It was dismissed for poor pay history, which was 0%. And therefore the case was dismissed and automatic stays issued were terminated. The court will also note.
So she filed for bankruptcy and made 0 payments. So the bankruptcy was dismissed, is what I'm gathering. And then so she's filed for bankruptcy again, expecting that to stay her eviction proceedings.
That the documentation that was submitted by Ms. Stevenson to the court indicated that there was a skeletal bankruptcy petition that was filed. And Ms. Stevenson, what date was that skeletal bankruptcy petition filed? You're muted, just so you know you're muted. Please unmute. I'm sorry, what?
What are you talking about?
Well, your attorney on your 23 bankruptcy case filed a skeletal bankruptcy petition. What date was that filed?
It was filed completely. I don't know what that word means that you're saying to me. What is skeletal?
I'm reading from the document that you sent to the court. Your attorney stated that they completed a bankruptcy
The
analysis.
document that
reviewed all
I
of your-
is
Excuse me. Excuse me.
it's
Please,
that
please stop,
that is
please stop interrupting the court because we can't record more than one person at a time.
give me a question.
Oh my God.
Give me a question. Let me ask.
Ms. Stevenson is no longer on here. She dropped off. The court did not remove her. I'm just making that a record right now.
Like, she just starts screaming like that. It's insane. Oh, she's back.
Ms. Stevenson, please unmute.
You guys would not let me say anything in this courtroom.
Just one moment. Just one moment. Your connection has not been good. And when you start answering a question, I'm not hearing everything you're saying, so I'm asking you to stop talking.
Okay,
so
well,
that
I'm
you can-
talking right now. I am talking right now, Your Honor. I'm talking.
No, you're not talking. I just muted you. Now, please stop, because I see that you're still talking.
And she's just going and going and
You
going.
can continue to waste your breath. I muted you because your connection is poor. I cannot hear what you're saying because it's breaking up. So, have you moved to a new location? Have you moved to a location that you have better connection? Just so you know, I muted you, so you'll have
Yeah.
to unmute.
Look, she's like screaming. Crazy.
You in chat. Since you can't hear me, I'm gonna type you in chat.
I'm sorry, what is
Oh,
that?
she's.
I'm going to type you in chat.
No, we don't have chat enabled, ma'am. You cannot send a message to the court via chat.
Well, I'm letting you know you're not supposed to be here. My bankruptcy has been filed.
No, ma'am, that is
My
not accurate.
bankruptcy has been filed. You guys
Excuse
go
me.
to the bankruptcy if you do anything or try to get anything.
Look at her. She's like pointing the finger at the judge and everything. Crazy. She's insane.
It's on my record. I don't care. It better not be on my record.
Excuse me. You need to calm down. Excuse me. You need to calm down, ma'am.
Because I'm supposed to be here. I'm an attorney. I'm supposed to be here.
Oh my gosh.
Okay, Ms. Stevenson, excuse me. Well, the court muted Ms. Stevenson because we can't catch much of what she's saying.
Oh, now she's unmuting herself. So if you caught it there, I don't know, because her sound is so bad. Hopefully yours didn't get blown up, but she's screaming that she had rights. Meanwhile, she's screaming at the judge. Wow.
Ms. Stevenson, stop talking. Stop talking. We cannot get what you're saying on the record because you're screaming and you don't have a good connection. So stop talking, please. Stop talking. Stop talking. Stop. I am not one of your children, ma'am, so you need to stop. You are speaking to a court. You are in court, so you need to have some respect for the court. So, as I was saying, Ms. Luckoff, there is not another case that Ms. Stevenson filed.
She's still going. She's on mute. And she's still going. And the other lawyer up here is just like sitting there like afraid to move.
In 2022. The court will note.
And look, she's like, it looks like she's got a picture of her children as her background too. And she's sitting there screaming at the judge.
That actually, Ms. Luckoff, can you pull up the names, the bankruptcy court filing to see when this bankruptcy petition was filed, please?
This
See if it was
one?
before May 3rd? Yes.
Okay.
The case number is 23-44007.
Okay. Okay. This says date filed 4/30/2023. Oh, excuse me, 4/30, Your Honor, 4/30.
On a Sunday?
That's what it says. Let me just,
Okay,
I'm going to open the petition here. See what we have here. If that comports. Yes, it says 4/30/2023.
Okay. All right, so what the court will note, counsel, is since there was only one case filed in 2022, well, actually, I'm sorry. When you open up the case, does it show if there is any motion that was filed along with the petition?
And she's gone again. I wonder where she went. Maybe to catch her breath.
Look here. Okay, so it says petition, statement of social security number. I won't read you the whole thing, but let's see, motion.
Oh, she's back.
No, notice of missing documents. There's no, I do not see a motion, Your Honor.
Okay, so,
You guys mess with me if you want. I'm letting you know this now. I'm letting you know this now.
I'm letting you know to stop interrupting the court or you will be held in contempt of court. Stop.
Hold her in contempt. She's like threatening you. Hold her in contempt.
Stop. Stop. The court is going to state that the petition was filed on April 30th. So there's 14 days to file the balance of what needs to be filed, which puts it to May 14th. And so, counsel, because there was only one action filed in 2022, there is a 30-day automatic stay that was triggered. So I cannot enter a judgment stay, but what I will do is I'm only going to set this out for 2 weeks, well, less than 2 weeks, because I'm going shortly after the 14 days by which the balance of the documents need to be filed or the bankruptcy is dismissed. I'm not going out 30 days right now. So the 30th day would be on May 14th. We don't have a docket on May 19th because of the mandatory judicial conference. So counsel, are you available on May 16th at 1:30 in the afternoon?
I will make myself available, Your Honor.
And we are doing this in person.
The only thing I need to confirm, give me 1 second, is I have an in-person. Nope, that's on the 15th. Okay.
You guys can contact my lawyer.
Excuse me, Ms. Stevenson, your lawyer has not filed an appearance here at all. So
He will.
your lawyer doesn't have, excuse me, then that's fine. Then your attorney will know how to proceed. You need to be here in person on May 16th at 1:30 p.m.
Why?
Because the court is going after the 14 days. We're setting this after the 14 days to make sure if the bankruptcy case is still proceeding or if it's been dismissed. So that is why the court is set for May 16th. Stop interrupting me. Stop interrupting me. May 16th at 1:30 p.m.
I will not be there.
Well, if you're not here, the court will proceed without you. You can have your attorney present, but you need to also be present. So May 16th at 1:30 p.m. in person at the courthouse here. Thank you. We're off the record.
Thank you, Your Honor.
Thank you.
I won't be here.
Wow. All right. So that was that one. She was quite the oh my gosh, quite the Karen. She was filed bankruptcy, never paid it. So they were asking for it to be dismissed because she never paid on the bankruptcy. Then she filed it again, hoping that it will delay her eviction, but she didn't file it properly. So she ended up getting a 2-week delay there in the hearing. So I don't know what happened, but yeah, she was quite crazy, threatening the court, yelling and screaming. So Mimi, this woman is her own worst enemy. Yeah, quite often they are. Quite often they are. So hey, Lex, good to see you. Oh, no worries for being late. No worries for being late. So, actually, I think so. I think the videos are quite long. I know. So let me know what you guys think in the comments below. If you like the format, I can try and find some shorter videos to react to. But sometimes it's quite when we're dealing with court videos. It's I don't know. For me, I like to see the whole context, but I understand not everybody will. So, let me know your thoughts below on how you think the stream went. I am going to see if I can look up some pointers on how to better utilize StreamYards for reaction type videos or live streams. So maybe I'll reach out to a couple of fellow YouTubers on Twitter and get their opinions as well. So I do have a few more saved. So if people liked it, we can do it again. Like I said too, I think I'm going to cover the sovereign citizens a little bit as well, because some of them are like way out there as well. They're especially some of the Canadians. I've seen some Canadian sovereign citizen videos where they try to rely on the US Constitution. So those ones are really funny. So maybe we'll watch a few of those next time. So, yeah, so I'm going to wrap it up for tonight. So watch those of you on the replay, thank you for coming and watching. Hopefully you stick it out. Please feel free to fast forward because I was definitely not on my game tonight. So I was a little bit tired. I couldn't quite get my words going there a bit, but and I'm gonna stream. So I'm going to link the channels for whose videos I use tonight. So please, guys, go like and sub up their channels. They've got tons of awesome videos to watch, especially if you like watching court proceedings. And yeah, so I think that's it. I'm probably not going to be able to stream till sometime next week. I'm just thinking probably Monday or Tuesday again, I'll be able to stream. I've got some stuff going on the weekend, so I'm not going to have too much free time. Sorry about that. Just had to mute there. Yeah, so I'm not going to have too much free time, so I probably won't be able to stream again on the weekend. So look out for my next stream. Any topics you want me to cover, again, please throw them in the comments. Actually, before I go, and well, there's a few of you in here, I wouldn't mind getting your opinion if you don't mind putting it in the chat. So I saw a documentary a few days ago about how prevalent now it is for, and just going to tell you that what I'm going to talk about now deals with SA. So if you don't want to listen, that's fine. But how you guys, I'm sure many of you probably heard about that case in France where a woman's husband was drugging her and allowing men to SA her while she was unconscious. So apparently something very similar happening here in Canada as well very recently. And I was just watching a documentary on it, and I'm actually quite surprised, although I shouldn't be, but I am quite surprised of how big of a operation this is. And I kind of wouldn't mind talking about it sometime. I understand if people don't want to talk about it, or maybe don't want to, discuss such topics. I know YouTube's kind of iffy on those topics too, but the documentary I watched was on YouTube, and the documentary channel didn't like beep out any words. They were quite graphic in what happened. Now I won't be as graphic, but yeah. So if that's a subject, maybe you guys would be interested in. One of the reasons I do want to talk about it is because I think so many people are unaware of it happening. So this is apparently a thing where husbands, spouses, significant others are drugging their wives, girlfriends, and then allowing them to be assaulted, but not just allowing them to be assaulted, like some really horrific things, but videotaping it and then putting the videos out there on the internet. So yeah, so I was just like, I actually had to watch the documentary in bits and pieces because of the topic. I do understand it will be a very triggering and very sensitive topic, but I do think it's one that's worthy of discussing. So, all right. So you guys seem to be open to maybe to hearing about it at least. So yeah, okay. So maybe then I'll look at doing that as my next stream because I think it's something that that deserves to be talked about. So just to make people aware. So yeah, apparently he did get away with it. And so did the person here in Canada that was recently charged with it as well. So yeah, so like horrifying, horrifying, horrifying. And again, if I can, I don't know because this was like a documentary channel. I don't know if I'll get dinged with copyright if I try to play little clips from their video, but I'll try it. I mean, hey, I'm only a small channel, so maybe I won't. We'll see how it goes. So, all right. Okay. So, yeah. So, okay. I'll probably plan that for my next live stream then. If not, we will see. But thanks for coming out tonight. I appreciate you all that were here. I appreciate everyone who watches on the replay gang. And I hope you guys enjoy the rest of your week. I hope you have a nice weekend, and I will see you all soon. So thanks for coming out again. Have a good night, everyone. Bye.